SJC-12232, Commonwealth v. Jamal Brangan.
Mr. Schnipper, good morning again.
Morning, Chief Justice Gantz again, and members of the court once again. I'm Merritt Schnipper here on behalf of Jamal Brangan. As of today's date, the defendant has been held at the Hampton County Jail for 1,202 days because he cannot afford to pay for his freedom. Excuse me. He's affirmed his inability to post tens of thousands of dollars of bail repeatedly to both the Superior Court and to the single justice, but has been denied. He's asked these courts to explain why bail set beyond his proven inability to pay is fair, but he has been refused. He's asserted his constitutional rights to equal protection, to be protected against excessive bail and to due process, and has asked both courts to connect the measure of bail here to those rights and how those rights can be asserted consistently with this excessive bail, but has not been heard. And so he remains in jail nearly 3.5 years after he was arrested. The defendant has never defaulted on a court appearance or even missed a probation appointment, and the Commonwealth has not asserted otherwise. When police contacted him and said they wanted to speak with him about a robbery, he met them where he said he would and submitted peacefully to arrest. There is nothing to suggest the defendant will not appear for retrial or other proceedings, even if he is simply released on recognizance. And yet he remains in jail where he's been for nearly 3.5 years because he is too poor to come up with either $70,000 or $40,000 to pay for his release. This result cannot be squared with fairness and equal justice.
Now, before we get into the law, help me to make sure I understand. I gather that after we issued our decision, then you, which said that the conviction, that the judge's order should be viewed as a mistrial, and the fact that it was done after the verdict is of no consequence, and the Commonwealth, I guess, chose to pursue a new trial, and then you have moved for the Superior Court for the case to be dismissed because of double jeopardy, and
Correct.
I guess we have that case now since you appealed the denial, and that's going to be heard by us in the fall?
September, yeah.
Okay, so pragmatically, this case is not going to go to trial, if it goes to trial at all, until we resolve the case in September, which is likely to be in the ballpark of Thanksgiving or Christmas.
I think that's a fair assessment.
So what's at stake here essentially is if he is to be held through the end of this
Probably the end
year.
of the year, and I would add that would get his arrest was in January 2014, so you're then talking about 4 years. So I think the excessive nature of that time in the county jail speaks for itself.
Remind me what the charge is that he's being held on.
It's armed robbery while masked.
Okay.
And the facts are a bank robbery with a note passed to the teller.
Is there still a bail on the probation?
There is. The current state of affairs is $20,000 on the probation, $20,000 on the main charge, but the only probation violation alleged is the main charge, so it's functionally all based on the new charge.
And as you know, in the district court, usually you have an order of custody and somebody's either held without bail in a probation violation matter or they're released. So how does that square with your argument?
Well, it really doesn't because we're in the Superior Court, but I think that the real point here is that there's really been an extensive proceedings around this indictment. And without having to cast blame for those delays, although I'm ready to cast blame, frankly, without having to cast blame, I think the real point here is that for a person to be forced to endure those proceedings behind bars is both inconsistent with their presumption of innocence and really cramps their ability to exercise the rights that they're guaranteed under the Constitution. And I would just point the court specifically, the Commonwealth at page 12 of its memorandum suggests that the defendant could have shortened these proceedings and shortened his time in jail by simply deciding not to assert his double jeopardy rights and upon the dismissal deciding not to appeal them. So I can't think of a better illustration of the equal protection denial at issue here with the idea that a person who was of means and thus could post bail and await the proceedings outside of jail, no one would submit to a second trial without testing the sufficiency of the evidence of the first if they had a viable double jeopardy
Counsel,
argument.
can I just ask, do you have a problem with the constitutionality of the statute generally or as applied?
So certainly not generally. and only as applied in as much as it does not require judges to ascertain ability to pay bail as part of the financial resources assessment that it already commands. So I don't really even think, I mean, it's an as applied in the sense that it, by not requiring that the bail be something that he can afford.
So if someone's completely indigent and they can only afford a $100 bail, the judge has set bail at $100?
I think that is the requirement, but one of the things that the
They
whole...
have 13 defaults on their record,
Well,
$100?
obviously, these are all factors that need to be considered, but one of the things I think that's very important and that is discussed, has been really the constitutional law of both the Commonwealth and the United States for many years, is that there are a lot of alternative mechanisms to get a person back to court if they don't have any money. Let's imagine a person who can't afford $100 in bail. Well, obviously there's a GPS tracking option that's available. There are other check-in mechanisms, probation supervision, phone check-ins. And in Bearden v. Georgia, this court in Gomes in 1990 said that, you know, if you're going to incarcerate someone for non-payment of a fine, or even consider non-payment of a fine as a basis for incarceration, you need to examine their ability to pay before you can. Otherwise, it's a due process or equal protection violation. If that's the case with the liberty of a person who has already been convicted of a crime, and we're talking about the execution of their punishment, that argument applies with even greater force to a person like the defendant here, who's still enjoying the presumption of innocence as being held pre-trial.
Mr. Shipman, I want to make sure you're not arguing more than you mean to. So if the amount that you need to assure the appearance of the defendant for trial is more than the person can afford, but is the amount necessary to be able to secure the person to appear for trial, are you saying that there has to be a lower bail, or are you saying when you look at all the enumerated factors under Section 58 and you get to the factor of financial resources, that the ability to pay needs to be part of that equation?
It not only needs to be...
Now, which one of those two are you arguing?
Well, frankly, I think I'm arguing a kind of a hybrid of those two, because what I'm arguing is that the ability to pay absolutely must be part of that calculation. And I'm arguing that bail set beyond someone's ability to meet is simply not calculated solely to assure their reappearance at trial. Let's take the case here. What is it, and the defendant specifically requested, I specifically requested from the Superior Court multiple times, findings on what the relationship between the facts the Superior Judge found. You were on probation, you have this record, you know, this is your mental health status. What is the relationship between those facts and this number? Because the way things work now in both the district and the Superior Court is it's not as though anyone explains the correlation between those numbers. What they say is, well, the Commonwealth's asking for this, the defendant's asking for this, here's the facts, here's a number. Sometimes you can get it reduced, sometimes you can't. But if a person cannot pay it, they're being denied bail. I mean, there is no, you know, I mean, let's not, you know, the idea that you're granted bail that you can't afford and somehow you've been freed, but you're just somehow coming up short, that's exactly the situation that this court just addressed last year in Commonwealth versus Henry. I mean, you cannot impose a financial term that puts a person at risk of imprisonment without consideration of whether they're unable to pay, because you're basically talking about a willful or default. I mean, if it's through no fault of their own, they're not being contemptuous, they're not refusing to satisfy the court's order. What they're doing is saying, I'm too poor to meet this condition you've put on me. And the defendant here specifically said he has $5,000 he will post, which is a lot of money for him. He was found indigent in 2014. He's making that argument mid-2015 after he's been incarcerated for 18 months. And he says, and I'll wear a GPS tracker, I'll do a curfew, I will do what you want me to do. Please let me out so I can return to my home, assist the people I live with who are sick, help them with their daily needs. I mean, all the issues that this court addressed in Henry are here on the table, but with a presumptively innocent person rather than a person who's been convicted of a crime and is simply, you know, being adjusted in the execution of their sentence. So I think what we really have is just an administration of justice issue. If you're going to set bail, if you know, which at the second and third hearings, the Superior Court knew, and the prosecutors who were arguing for the bail knew, that the defendant could not satisfy the bails they were going to impose. So it was known in advance that the bail setting and the bail adjustment was going to result in continued pretrial incarceration. How is that admitting a person to bail? I mean,
Counsel, may I ask, okay, suppose the judge in the Superior Court gave you a reason and said, I'm considering ties to the community, the facts of the case, I'm considering ability to pay, But I still think that we need $20,000 to ensure his presence for trial. Would that be a problem as far as you're concerned?
Well, it wouldn't be a problem as long as the ability to pay ascertainment had determined that he had the ability to pay the bail that was set.
Oh, so your inquiry requires the judge to make a determination that the defendant can pay what is being, not as one of many factors.
Right, I think that
Okay.
needs to be a factor that is singular.
Okay, so the judge has to set a bail that the defendant can pay regardless of whether that would ensure his presence. I mean,
Well, I mean, obviously, a bail that the defendant can't pay is guaranteed to ensure his presence, but there's a dangerousness procedure for one group of those folks. And then there is, I mean, if you can make a determination, like, the kind of the leading case is this court's decision in Querubin. That's where the, bail is not excessive simply because you cannot afford to pay it comes from, and that's repeated quite frequently. That person, fled from police when they showed up to arrest him. He was on the lam for a year, and they arrested him at the border in Mexico trying to cross over. So I think it's pretty fair to say we had a flight risk on our hands, and I think to basically say, look, we're not going to be able to release you after this on bail because you've proven that you're not going to show up and answer for the charges.
so what about the person who has 20 defaults?
Well, then what about putting a GPS tracker on them? I mean, that's moment by moment, right? I mean, so then,
So you give them a head start?
a head start. Well, I mean, with the GPS, you're going to be able to locate them pretty quickly.
Right, so you give them, the person has 20 defaults, you give them a head start.
I'm not sure what a head start
and
means.
who decides how much the defendant can pay?
The judge.
So the
Well, I mean, with
judge
the
asks,
assistance of probation.
so the judge asks the defendant, how much can you pay? And he says $200, and that's the amount?
Well, no, I
What
mean, there's an
defendant is gonna
indigency
say-
determination that's done with the assistance of probation that assesses assets, income, benefits, dependents, their requirements, rent, all these things. I mean, it's a global determination. And just like this court said in Henry, at the time you are first charging a
So the
person, you're doing.
defendant fills out a form
Right, well, I mean,
that speaks for what his assets are.
Under
And the judge
penalties
looks
of
at that and
perjury.
says, okay, $200?
well, first of all, the sign is under penalties of perjury. I mean, I think to presume that, and when I was arguing for the GPS in the Superior Court, the Commonwealth said, well, how do we know he won't cut it off? Well, that's a crime. So how do we know he won't subject himself to further criminal penalties? I suppose we don't, but that's a pretty significant countervailing interest. And obviously, if you violate the terms of your release, then you're subject to being held because you violated the terms of your release. But I mean, I would frankly say, look at this case, and what's the incentive for a person to behave like the defendant did? And when he's reached by the police, say, here's where to meet me. I'll come meet you. I will submit peacefully to arrest. I will work this process through the judicial process. I mean, what's the incentive? I mean, I think it's one thing to talk about the global set of cases, and I think that CPCS memorandum addresses it very well, frankly. But our case is very specifically about an individual who has conformed to the expectations of the court and the police. He's submitted to arrest. He has not in any way ever failed to show up for either probation or court. And yet he has been just brutalized by 3.5 years of pretrial incarceration. So, I mean, what we need is an answer that does not simply say judges have discretion to set an amount beyond what a defendant can pay for his freedom.
Do you think this will lead to a lot more dangerousness hearings if we were to interpret the statute the way that you say we should? In other words, judges would be at the behest of prosecutors thinking of ways to keep people behind bars that have nothing to do with.
I mean, I think that's a realistic concern, yes. I'm going to presume that the better angels of my prosecutorial brethren's nature will not allow them to move for dangerousness hearings unless it's appropriate, actually appropriate. And of course, they have a high standard of proof at those hearings, so I think that, judges are going to administer those fairly and are going to make those findings only when appropriate. But I mean, I think there's a danger of pushback against a rule that says ability to pay determinations must be made? I think there is, but I think that has to be dealt with as it comes up because I think the fundamental rights at issue here are so important and so basically just central to the administration of justice. I mean, I would point the court to the materials I submitted both in my appendix and as the exhibits to my memo, that were both the Massachusetts Attorney General and the United States Department of Justice have both taken the position, as well as federal statutory law takes the position, that you may not set a pretrial condition that's simply wealth-based that results in pretrial detention. So,
But that's not our statute. I know the
No, it's
case
not.
that you're referring
Sure.
to, and it's
It is
the
not our
same
statute.
bail set for everybody depending on the offense. And we have a very different statute.
right, we don't have the bail schedule, but the Massachusetts Attorney General has not weighed in on the federal statutes. The Attorney General has weighed in on our situation, not just our statute, because it's not our statute that's the problem. It's the administration of it in this very specific way. If a person cannot afford to pay for their freedom and they can't be released, they really are suffering a sort of an equal protection violation based on their indigency. And I just don't think that that's consistent with either this court's decisions or the federal or state constitutions.
If I can burden you with questions beyond your time.
I'd love that.
Well, you may not.
Try me.
Querubin, court said no bail, no amount of bail can ensure his appearance.
Right.
This court affirmed it for various reasons. Person was part, arguably, of a substantial drug organization, and the thought is that whatever bail we would set, arguably, they can meet. Are you saying that a court cannot impose a bail above the ability to pay? Or are you saying that when a court sets a bail above the ability to pay, the court is essentially doing what the court did in Querubin and saying, for all practical purposes, I am going to impose an amount of bail that you cannot meet, and therefore I would need to make a showing comparable to a Querubin showing that would justify what is, for all practical purposes, the denial of any bail that can be met?
I think that would be a legitimate compromise. I mean, obviously, if you have a situation like that where you have a large-scale criminal enterprise in which the defendant there's probable cause to believe he's a participant, you clearly have a different assessment of the available financial resources than you have in most indigent defendant cases. So, I mean, obviously, that very specific subset, I mean, that's really just a variation of the ability to pay determination, right? Because what you're really saying is we're going to look at certain facts, and the Commonwealth would still have that burden. Here's a continuing criminal enterprise that's a large-scale drug distribution network that this person is a lieutenant in, and they're going to have the assets to make whatever bail and still disregard it. I mean, that's a very specific showing. There's nothing like that in this case.
No, I'm not suggesting there is, but for all practical purposes, when a court sets a bail of $100,000 or $40,000 for somebody who plainly can't meet that, the court is effectively saying, I'm not going to release you on bail because of the risk of flight.
That's right.
Querubin doesn't require any special findings.
Well,
do that.
similarly to the way I'm urging the court to interpret the bail statute, I think you could sort of reapply that case or look at the lessons of that case and say, going forward, it does need to be subject to a certain set of findings that are far more rigorous than what we've got going on now. Because what we've got going on now is kind of, it's quite possible a different judge would have looked at this same defendant's record in history and said, let's do the 5,000 and GPS because I think that will get you back here. And obviously, the idea that that's simply because that's what the defendant has affirmed he can pay and there's no contravening evidence, then what we've got is a very differential application depending on the luck of the draw of who you get for your bail hearing, your arraignment. And I just don't think that that makes sense either. We need a uniform standard that ties someone's ability to pay and sort of the fairness of that procedure across all defendants. Because like if a person of means had this exact same bail placed on them, there's no doubt that he or she would post that bail, test the sufficiency of their evidence, fully litigate their rights, and not have to do so at the price of such a compromise of their most basic liberty interest.
Well, the person of means would have a higher bail. The judge wouldn't set it at $20,000, set it at $200,000.
Well, I mean, and if that bail was beyond that person of means' ability to pay, we would have the same problem. I mean, we have an issue because in Amy, way back when, before the bail statute was revised and the dangerousness statute was put on, this court specifically said you may not use bail as effectively a preventive detention mechanism, right? That's a separate thing. That's why the legislature created 58A, and that's why there's a heightened showing that's required from the Commonwealth to detain a person subject to those rules without bail, right? So, I mean, I think that what we're basically doing is slipping back into, I guess, there being a category of people for whom there is no dangerousness finding that can be made, and this is certainly a case here, well, like that, or the Commonwealth has never even attempted to make such a showing. And yet, for whatever reason, folks don't want to release. Now, the defendant basically endured this through his first trial, but once we started to accelerate into the extended appellate proceedings, you know, and that's when I went into the Superior Court and said, we need to reduce this bail because this person has been in jail for so long. Rule 36 protections have been stripped, which is another aspect of the Queribin decision. They say no matter what the temporary deprivation may be severe, but it's temporary because you have a right to precedence in the movement of your trial through the courts because you're held, and you can press your speedy trial rights by motion. Well, those rights are gone here, right? And they're gone largely because the Commonwealth took an appeal that in the end was not vindicated by this court, to put it kindly. And I was saying throughout that proceeding, please hear the double jeopardy issue now because my client's going to be enduring this entire process behind bars. And if you don't hear it now, I'm simply going to be back here in a year and a half with the exact same argument and the exact same record. And although it's only going to be a year and 4 months, it's pretty close, right? I mean, he's had to endure this entire procedure behind bars. And I just don't think, I mean, the courts do things for the reasons that they do, and, you know, defense counsel and prosecutors do the things for the reasons that they do, and there may be all legitimate reasons, but the idea that a person, because they're poor, has to pay the costs of those reasons with their freedom is just simply incompatible with the most basic constitutional protections.
Counsel, one more question. How does, in practical terms, how does the probation violation factor into this, or the alleged probation violation? It's in Superior Court, isn't it? It's
Yes,
not
it
a
is.
district court probation.
That's correct.
Right.
So it's a bit of a strange scenario because the judge said he wanted to move the probation violation determination with the jury verdict. And then after the verdict was resolved, or well, after the closing argument, the mistrial motion, the verdict, and the mistrial grant, the Commonwealth said, could you please move forward, you know, make a decision on the probation violation? The judge said, no, I'm going to leave that for the jury, as was my plan. So we're kind of in limbo with that too. But I think, at least for my argument, the most fundamental aspect of the probation issue is that it's solely tied to this new charge, so that we're really tying the entire bail to the arisal and, I guess, eventual resolution of this new charge, rather than being some other probation violation, either a technical violation or some other act.
Okay, thank you.
Thank you very much.
Good morning. May it please the court. I am Amal Bala for the Commonwealth. The Commonwealth is arguing that no abuse of discretion exists here and that the amount of bail has not violated any of the defendant's constitutional rights. In Superior Court, the bail judge gave fair consideration to the necessary factors under the statute. General Laws, Chapter 276, Section 57, is the bail statute that applies in Superior Court. The bail judge in this case used a pre-printed district court form that references Section 58, but for clarification, it is Section 57. The judge could probably find that the charge of armed robbery while masked is in fact an allegation of a serious crime. The defendant has a record of prior convictions. He pled guilty in 2001 to numerous counts of raping a child. The penalty upon a guilty verdict could be severe. The defendant was on probation when arrested. He has a history of abuse prevention orders issued against him, and he has a history of mental illness. So the Commonwealth is arguing that based on the defendant's record, $20,000 from the indictment of armed robbery while masked is entirely reasonable, and $20,000 for the alleged probation violation is also reasonable, and that the judge essentially made appropriate findings under Section 57.
Doesn't the judge have to consider the ability to pay as one of the factors?
No, Your Honor, I do not believe that he does.
Doesn't it speak of financial resources among the factors to be considered?
In Section 57, I do not see any indication.
58 factor, but since it's listed under Section 58, is there a suggestion that should be considered an enumerated factor under Section 57?
I don't think so, Your Honor. The bail judge in this case, for whatever reason, used that pre-printed form that said Section 58, but I think a more fair interpretation of what happened here is that he essentially just used that piece of paper and was really conducting analysis under 57.
But you just listed all the Section 58 factors as you were marshaling your argument. And that's what happens in the Superior Court, too. When the judge is doing a determination under Section 57, the judge has in mind the enumerated factors under Section 58. Financial resources is one of them, and while not dispositive, somebody's ability to pay should be included in that calculus, shouldn't it?
I would say no, Your Honor. In this situation and in all cases, ability to pay should not be a factor. The new rule that the defendant is proposing essentially would be...
So if Bill Gates had committed a crime, you would not consider his wealth as opposed to somebody who was a pauper in setting bail and determining what is the amount of bail necessary to assure his appearance at trial?
Well, yes, Your Honor. In that type of situation, I suppose that there would be...
Maybe he's not Bill Gates. Maybe he's just a guy earning $100,000. Would that not be appropriate to consider in setting bail?
I don't think so, Your Honor. And
How? How could you not? Where does $20,000 come from? I mean, is $20,000, I mean, or $40,000? I mean, is that...
yes,
would that be an appropriate amount for somebody who was of immense wealth, for whom $40,000 would be viewed as a... I mean, there are sports figures who get $40,000 for doing inappropriate things on the basketball court.
yes, Your Honor. And essentially that amount is calculated to secure the defendant's presence at trial or at any court hearing. And in that regard, if an extremely wealthy person gets $40,000 bail on similar indictments or charges as these, I would suggest that that is entirely appropriate, even if he or she is a millionaire, because that amount is calculated by the bail judge in consultation with these factors in Section 57 to determine what amount is necessary to ensure that this person comes back to court. So even if someone is extremely wealthy, I would suggest that the factors that are in the statute give judges proper guidance to make a fair and reasoned determination as to what amount needs to be set for this limited purpose of ensuring a defendant's presence in court.
Now, there's been no claim that he's dangerous.
No, Your Honor.
So the only issue is what amount is necessary to ensure his appearance.
Yes, Your Honor. Under the case law, that is the essential factor at issue.
Okay, and is there any material dispute that $40,000 bail is more than he can meet?
Well, taking the defendant and counsel at their word, I don't think there appears to be no dispute that the defendant cannot pay that amount, apparently.
Okay, so whether it's $40,000 or $40 million, it is, for all practical purposes, the same thing.
Yes, Your Honor, it appears to be that way in this case.
So let me ask you the question I asked your brother. Should we treat this case in the same way we would a case in which the judge says there is no amount of money that would assure his appearance because effectively the judge has done just that, set an amount which the person cannot meet?
No, Your Honor, I don't think so. I think that...
Why not? What is the difference between saying I'm not going to impose bail versus I'm going to impose a bail that the person could never meet?
Well, frankly, we don't know whether the defendant ever could or could not meet this amount of bail. Conceivably, I mean, we might be speculating, but conceivably, he could somehow come up with $40,000. We don't know.
Well, he hasn't in 3 years.
He hasn't for 3 years. That is true, Your Honor.
So.
But I suppose I'm suggesting that if we start treating any amount of bail that is perceived to be beyond a defendant's ability to pay as the functional denial of bail, I think that kind of new way of looking at bail is entirely unnecessary and contradicts the purpose in this Commonwealth of why we have bail.
Well, that may well be true, but if the judge cannot consider as a factor the defendant's ability to pay, as a factor in setting an amount, then what you really have in certain situations is the functional equivalent of preventative detention without the procedural protections required by United States versus Salerno, don't you?
Well, the case law in this Commonwealth is that a defendant has no constitutional right to be released on bail prior to trial at all. Of course, due process rights are always there, equal protection rights are always there, but there is no right to be released on bail prior to trial. That right simply doesn't exist under the case law in this Commonwealth. So the Commonwealth is essentially arguing that this new system of bail that the defendant is proposing, first and foremost, is entirely unnecessary for this court to even reach that issue to dispose of this particular appeal. It's just not necessary for this court to decide. But in any event...
But that's not the end of the story, because there's the Eighth Amendment. And so the issue is whether or not dispositive, but along with everything else, somebody's ability to pay has to be taken into account. Otherwise, you have preventative detention. And if you have preventative detention, the Eighth Amendment is going to require the procedural due process protections of United States versus Salerno. And so I don't understand how it can't be a factor, constitutionally.
Well,
not dispositive, a factor.
Yes, Your Honor. And I would say that part of this issue goes back to the well-settled case law that merely because a defendant cannot post a particular amount of bail doesn't mean that it's constitutionally excessive under the Eighth Amendment or Article 26. That has been the law for quite some time in Massachusetts. So I think that's at least something to consider, that if this court were to adopt the approach that the defendant is proposing, that would essentially turn the case law on its head regarding excessive bail. And I simply don't think that's necessary for this court to do to dispose of this case.
Well, what would be the answer then if we don't do that? You say it's not necessary. What's your alternative approach to a resolution?
Of this case or of his proposal for...
Well, you say we shouldn't do what he wants us to do. What should we do?
Find that there was no abuse of discretion by the single justice in finding that there was in turn no abuse of discretion by the bail judge in Superior Court.
And just ignore the constitutional question?
Well, I don't think that... I think it's clear that the defendant that any defendant has no constitutional right to bail prior to trial, and I think it's equally clear under case law that bail isn't excessive merely because a defendant cannot pay it. And so I suppose that I'm suggesting that the solution here is to find no abuse of discretion and to leave the case law the way it is, because the current system of bail works properly.
Shouldn't we clarify that ability to pay should be a factor that all judges should take into consideration? Never mind the fact that the defendant, as counsel suggests, gets to name the bail they want. Putting that aside, wouldn't it be wise to just inform the trial judges to take ability to pay if it wasn't if it wasn't considered anyway, just to make it expressly clear that should be a factor?
I don't think so, Your Honor. I think that would...
Why not?
I think that would be too inflexible, and it would take away discretion from judges.
The discretion is, as the chief said, if it's Bill Gates versus a pauper. That's something judges consider all the time anyway.
True, Your Honor. It's simply too much of a restriction, I would suggest, on the discretion of bail judges, and there would be essentially no way for a bail judge to know whether a person can pay or not pay. Taking this case, the defendant is saying that he can't pay $40,000 cash total, but if the bail judge were required to consider whether he can pay that amount or not, there's really no way for the bail judge to know. The defendant can stand up and say, I only have
So for all factors, counsel, there's really no way to know any of it. It's all just based on what information is available at the time.
Well, I think it's much easier for a bail judge to credit certain established facts that are in the record, similar to those facts that I was essentially reading at the beginning. I think it's much easier for a bail judge to credit those facts than it is to require a bail judge to inquire into the amount of money that a defendant can pay, because money can come from different sources.
Isn't something a judge does all the time? If you're doing an arraignment and the person is involved in a drug conspiracy and the police has seized hundreds of thousands of dollars, don't most judges say, you know what, bail's going to be really high in this case versus someone on the Boston Common selling, one-hit packages of crack cocaine who's destitute? They get different bail, don't they?
They do get different bail, Your Honor, but I think that they get different bail primarily based on the facts and circumstances of the case or the allegation. If there were a requirement that a bail judge in that situation has to consider whether the defendant can pay the higher bail, then that's going to curtail the judge's ability to set bail at an appropriate amount. With regard to all these other factors, there could be severe factors in that case that would strongly suggest that the defendant would not appear for trial.
But if ability to pay is but one factor, and the person has 20 defaults, that may trump everything, right?
I think it could trump everything in a bad way, that if ability to pay were
No
there.
default, or if they have no defaults. I mean, these are all considerations judges should take into account every day.
But if ability to pay were there as a factor, the person with 20 defaults could say, well, I can only pay $100 bail.
But that's
And
one, that's one of many enumerated factors. It says financial resources, and I understand what's saying section 58, I appreciate that, but I may have been wrong for 19 years, but for 19 years, setting bails, ability to pay was one of the factors I considered under financial resources. It seemed obvious to me that that would be part of the calculus on determining the bail.
In Superior Court, Your Honor, I would simply suggest that it's not, and that in the end, we have well-established case law that merely because a defendant cannot pay doesn't make the bail excessive. And there's no reason in this case or in any other similar case to overturn that well-established case law.
And what do we do if you had claimed that he was dangerous and had brought a dangerousness petition? That would trigger the requirement in 276, Section 58A, that says that the judge may not impose a financial condition that results in the pretrial detention of the person. That the legislature declared that in 58A, where there is a claim of dangerousness. Where there is no claim of dangerousness, why should a judge be able to impose a financial condition that results in pretrial detention of the person, where you cannot do it by statute if the person is claimed to be dangerous?
The legislature has simply indicated a different set of factors in Section 57 than it did in 58A, and on that basis, I would suggest that if a different result occurs, that is simply a function of the way the law is written.
Thank you.
Thank you, Your Honor.